All right, we are recording. Thank you.
Okay. While we're at it, let me just mention as well, it really would help if you've got any questions, thoughts, considerations, etc., that you just jump in, because obviously this is not a massive group, and we're just trying to tailor this as much as possible to what your needs and interests might be. So if you've got a way of doing that, either by using the chat feature or by talking to Deus Deity or whatever, please go ahead and do just that. Doesn't need to be at a set time or anything.
Okay, good morning. This is Brian Buckley. I just connected on the audio side.
Yeah, I see you that you're not connected. Great. If you're connected to the audio, I ask that you just mute yourselves, whether your phone or your computer, so that we don't see the background noise. But when you want to jump in, please do so. Just unmute yourself and jump in. I don't have you muted on my side, so you're able to control whether you come in and when you come in. And we, as I did in my training, Mark also welcomes those interruptions because we want to focus this to your needs.
Okay, thanks. I got that muted on, so I'm just coming through one source, the telephone now.
Great.
Thank you.
Okay, so maybe let's move on to the next slide. Oh dear. Okay, it did work. The next slide is just an outline of what it is I tried to cover. So I want to talk a little bit about eligibility or coverage, depending on what it is you want to call it. Maybe doing a little bit of a contrast between IDEA on the one hand and Section 504 and the ADA on the other. Talk a little bit about free appropriate public ed, again trying to contrast IDEA and Section 504 ADA. Then, there's a lot really in the ADA and in Section 504 other than FAPE, other than appropriate ed. And so I'd like to try to cover as much of that as has been developed, although there probably are things that haven't yet surfaced in the case law that maybe people will be developing, throwing at you, or asking you to deal with. There's a very limited amount of authority, but some, with regard to hearing officers' remedies, procedures, that sort of thing, with respect to Section 504. So that would be the next logical topic. And then I'd like to finish up by talking a bit about defenses that might be applicable in Section 504 ADA cases, and they might actually be somewhat different from what we're used to seeing under IDEA. One additional word before we get into the eligibility related stuff, the Section 504 and ADA standards for who is covered are identical. So I'll be talking a lot about Section 504 and ADA kind of as a group or as a single entity. As we'll discover, the regulations that flesh out Section 504 and the ADA do actually have some differences, but really only to the extent of the subject matters that they cover. So I'll try to explain that as best I can when we finally get into that. But for much of the time anyway here, we'll be talking about Section 504 and the ADA as a single thing rather than as two separate statutes, even though that's, of course, what they are. To move on to the topic of coverage or eligibility, the main point with regard to IDEA, the special ed law, is that if you want to be covered under it, you have to have one of the listed conditions in the statute and by reason thereof need special education. And that's the whole outline of it. There's language in the regulations that actually gives definition to the conditions like intellectual disabilities or hearing impairments or speech and language impairments, all of the different categories that could be included. But it does rely on the idea that a kid does have to be in one of those categories and then needs special ed. The big difference with regard to Section 504 is that the drafters of 504 and the advocates who are pushing for 504, as well as the ADA and the advocates who are pushing for that, were very reluctant to get into the business of creating categories of disability or identifying what disabilities are going to be included and which conditions might or might not be included. Particularly with regard to the ADA, that was very much a reaction against the idea that disability is a medical condition and the medical profession or medical establishment somehow has a special monopoly on disability issues. And so the idea was to create something much more functional in its nature. This is then what is also applicable to Section 504. And the definition that you see is the one in the materials on page 2. So the idea is that a disability means with respect to an individual physical or mental impairment that substantially limits one or more major life activities of the individual, or a record of that, or being regarded as having that impairment. And here's the bit of the rub. Under that general definition and the definitional provisions that followed it, the U.S. Supreme Court, in a series of cases, most of them from 1999 to about 2002, read those definitions fairly narrowly, with the result that in employment discrimination cases in particular, a lot of plaintiffs got thrown out of court at the phase of, no, you're not covered by the statute because you're not disabled enough, or you're not disabled under the terms of the ADA or Section 504. There was a reaction against that that culminated in the ADA Amendments Act of 2008. That didn't change that definition that I just quoted you, but what it did do is alter the definition of what a major life activity is, made some modifications as to what regarded as having such an impairment is, and specifically overruled a couple of Supreme Court cases with regard to things like whether the impairment is in a mitigated or a fixed or a treated type condition. So with regard to the further definition and what the 2008 Act did, it defined major life activities, and this is also on page 2 of the handout, to include things like seeing, hearing, speaking, learning, reading, concentrating, thinking, communicating, and working. Much of that had been in the regulations or in the statute itself, but it wasn't as clearly spelled out as it is now. And then it defined major bodily functions to include all sorts of just physical processes. So the immune system, normal cell growth, digestive system, bowel system, bladder system, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. Interestingly, that major life activity, including all those bodily functions, is to be evaluated in a non-medicated or a non-fixed type state, meaning that the coverage of people under this law has expanded greatly because of the 2008 Act. You know, I'm not exactly youthful, I would have to say, and I would say that of my friends and contemporaries, maybe 60%, I'm not really sure, are probably on high blood pressure medication. Well, that means they've got an impairment of the major bodily function of the circulatory system, and in an unmitigated state, it for sure would create a substantial limit on a major life activity. So it really is a great expansion of coverage, and things like learning, reading, concentrating, thinking, communicating would include large numbers of kids as well, and so the definition is really quite broad. The language about the mitigating measures or treatment or all of that is actually reproduced on page 3 of the handout. Doesn't include ordinary eyeglasses, but does include all sorts of other aids and things, and those are to be not included when you're considering whether somebody is covered under ADA or Section 504. There's even that regarded as provision, which is on page 2 again, and that one says you can be regarded as and still be covered under the definition of the statute when somebody simply thinks you have an impairment, not necessarily one that substantially limits. Although the ADA Amendments Act did provide that if you're only covered because you're regarded as, then you're not entitled to reasonable accommodations under the law. So the logical question then, and the one that's been posed by a number of people who've done work in the area is, so then does that mean that if you're covered under IDEA, you've got one of those listed conditions and by reason thereof needs special ed, then do you necessarily get coverage under 504? And there's actually a Section 504 regulation, 300.1043L, that says exactly that. And there are a few cases that say the same thing. I've cited the Spring case, which is actually a non-presidential Second Circuit case, but one that's quite recent. And I don't think that anybody would have serious challenge about the idea that if you've got one of those listed conditions, that would qualify as an impairment. And if it's enough that you would need special education, you could certainly argue that that would be a major life activity of learning or of reading or communication or whatever that would qualify as being substantially limited, even if it weren't for the fact of Section 104.3L. So I don't know that there would be too much contesting over that, except for the fact that there are a couple of cases that maybe go in the other direction. And oddly enough, one of these is also a fairly recent Second Circuit case, although it's a little convoluted. The BC case was a class action trying to make a point about the use of particular intervention services classes and saying that that was a violation of the ADA in Section 504, the way that New York put kids into those classes. The problem was that there were really no statistics available to show things like numerous numbers of kids involved that pertain directly to the ADA. So what the plaintiffs tried to do was use IDEA type statistics for that, and the court said, no, we're not sure that somebody who's just covered under IDEA would necessarily be covered under the ADA, and they go ahead and cite a bunch of pre-2008 Amendments Act case law under that, which seems totally, at least to me, odd. But they didn't seem to be terribly bothered by it. They rely on that one Ellenberg case that's also enacted, or that also was decided before the implementation of the 2008 Act. In any case, it seems to me that the stronger position would be that if you're covered under IDEA, you're also covered under Section 504 and the ADA, although, as I said, there might be some reason to view it otherwise. What more can you say about that? Well, probably the one thing that you would want to ask about it is, okay, we're covered under IDEA and or under Section 504 and the ADA, so what does that actually mean? The question as to what it actually means is some sort of difficult one, and I would divide it up, talking first about FAPE, or what we think of as appropriate education, or the kind of general duty to provide special education or adapted services of some kind to kids, and then sort of everything else. So everything else could include things like segregating kids or avoiding retaliating, or things having to do with communications accommodations, sort of everything that doesn't neatly fit into what might be a parallel to IDEA special education as that's generally been thought of. With regard to that, there really, of course, are two somewhat different definitions of what appropriate education is under IDEA on the one hand and under Section 504 on the other. And this is one of the situations where there's a Section 504 regulation and really no parallel ADA regulation. So courts in general have relied on the 504 regulation to give the interpretation of what the appropriate education duty is. In any case, you remember with regard to IDEA, and I'm kind of assuming that you've got or had some chance to either hear cases or otherwise be involved in IDEA kinds of proceedings, there's this basic obligation to provide free, appropriate public ed, and there had been big debates over just what that means throughout the many years in which the statute has been in effect. The guiding precedent for that, which I've cited on page 5 of the handout, is Board of Education against Rowley way back in 1982. Kids' parents want to have, for this child who has a very severe hearing impairment, a sign language interpreter in school. The lower courts say, we don't know exactly what free appropriate public education under this statute is. At that point, it hadn't been renamed IDEA, but under this Education for the Handicapped Act, we don't know exactly what it means, but we think that we can borrow the definition that's found for appropriate education in the Section 504 regulations, which talks about providing education that's commensurate or in some way meeting the needs of the kids with disabilities as well as the needs of kids without disabilities are met. That runs into a bit of a brick wall when the case goes up to the U.S. Supreme Court. The U.S. Supreme Court thinks that that's not what Congress had in mind with the statute that becomes IDEA. They thought that what it really meant was something more like a basic floor of opportunity. They didn't think that you could really draw meaningful comparisons between education for kids with disabilities and kids without disabilities, or in any event that Congress didn't require that. They did say that, yes, some educational benefit for sure has to be imposed, otherwise Congress wouldn't be spending all of this money on special education. But they also said that if you follow the procedures that are set out in the statute, it seemed pretty likely that that's what you'd wind up with. And what's more, for a kid like this one, who although she has this severe hearing impairment also has hearing aids and is, by the way, apparently extremely bright and hardworking, she can hold her own, is getting fine grades without that extra service, and so is not entitled to that under the law that becomes IDEA. That had sort of sailed along as the basic interpretation, with different courts of appeals giving one spin to it or another for the last 35 years or so, until this March, when the U.S. Supreme Court decided the Andrew F. against Douglas County case. Little different factually. Kid is a kid with a lot of severe developmental disabilities, and kind of going with that, problems with behavior and kind of just management of behavior in school. The Supreme Court was reviewing an interpretation that the 10th Circuit had given, that it upheld a program for the kid, even though the parents said that the kid had basically plateaued educationally, and although he was getting some behavioral services, they thought the behavioral services were not adequate to enable him to make as much progress as they thought that he had the capacity to make. The case lost all the way up to the Supreme Court, but at the Supreme Court level, it gets reversed in a unanimous opinion by the Chief Justice. The Chief Justice, interestingly, says, we're not saying that Rowley has been overruled. We're reaffirming Rowley, but Rowley itself didn't take up the topic of what about a kid who's got such a severe impairment that they're not in regular classes, and they're obviously not succeeding in regular classes. What do you do then? And is Rowley really meant to require nothing more than de minimis benefit, which is what the 10th Circuit had said that it requires? And they reject the 10th Circuit's interpretation. It's more than merely de minimis, that every kid is entitled to an appropriately ambitious program, every kid's entitled to the chance to meet challenging objectives. They reaffirmed the part of Rowley that said defer to the decision makers at the state and local level, but they also said that, you know, if the decision makers have made their decisions, they should be able to justify them as being appropriate to make the kid make progress under the kid's circumstances. They remanded back for the lower courts to try to deal with that. the upshot of it, I think, is that, yeah, the Rowley standard prevails. It's one that doesn't require the comparison with kids without disabilities, but it's higher than what at least some courts had thought that it is. And that's kind of what we've been dealing with on the special ed front ever since March, really. What about Section 504? Is that any different? Well, it kind of looks as though it has to be, because that's what the lower courts drew on in Rowley and what the Supreme Court seemed to have rejected in Rowley. What it does provide in its language is this idea that appropriate education is the provision of regular or special ed and related aids or services that are designed to meet individual education needs of handicapped persons as adequately as the needs of non-handicapped persons are met, and are based on adherence to the procedures in Section 504's regulations, which, you know, really does seem to require a comparison to kids without disabilities and the education offered them. And although probably when this was drafted, you know, before actually the passage of what's now become IDEA and way before Rowley, they probably did expect maybe that under the IDEA standard you'd have roughly the same duty, or maybe not, I don't know. But in any event, they came up with language that does seem to be much different from what the Rowley and now the Andrew F. Court have placed on the language in IDEA. So that then kind of raises the question, which is the one on the next slide. So if you comply then with IDEA, does that mean that you're complying with Section 504 in the ADA? The bulk of the authority says yes, even though you might be able to challenge whether that really is a logical conclusion or not. The bulk of the authority relies on Section 104.33b of the Section 504 regs, which says that implementation of an individualized education program developed in accordance with the Education of the Handicapped Act, or what is now IDEA, is one means of meeting the standard established under B1, which is that as adequately as the needs of non-handicapped persons are met. And most courts have essentially run with that and said, yeah, so therefore if you're complying with IDEA's appropriate education provision, you're complying with Section 504's appropriate education provision. I've given you a State of Lance, which is a fairly recent Fifth Circuit case, but actually a Ninth Circuit case, the KM against Tustin case, says roughly that as well. Is there authority on the other side? Well, I have argued that maybe there ought to be, because I think that you can read that 104.33b regulation to mean simply that the IEP under IDEA is one means of doing it, rather than if you've complied with FAP obligations under IDEA, then necessarily you've complied with them under 504, even though the standards look to me to be a lot different. The authority that is out there that maybe suggests that the appropriate ed standards might be different and might be of the nature that if you've complied with IDEA, you wouldn't necessarily have complied with the appropriate education obligation under 504, is language out of the Mark H case, which of course is also a Ninth Circuit case. This one, the Lemieux case, there's a Mark H against Lemieux and a Mark H against Hamamoto. The kicker with it is that I really have to describe it probably as being dicta, though, or in any case not something that is essential to the holding, because what the case involved was kids who had autism who alleged that they were basically getting no autism-related services at all. And so it seemed pretty clear that there could be both a violation of IDEA and of Section 504, although the Ninth Circuit, interestingly, seems to, with regard to those two things, apply rather different standards, including the Section 504 as adequately as the needs are met language of the regulations. So for what it's worth, that is out there as suggesting the standards are in fact different, but the bulk of authority seems to say if you comply with IDEA, you've complied with the Section 504 appropriate education obligation. So that's what I wanted to emphasize about that kind of cluster of stuff. There is then the logical question that I think falls next, which is, okay, we sort of get that. What if you've got a violation of IDEA? You've got an instance where the hearing officer or the judge or whoever concludes that the school district, the school system, hasn't met its IDEA obligations with regard to providing free appropriate public ed. Does that then create a valid Section 504 claim? There's authority saying that it is, but it's almost all out of the Third Circuit. And so it would not appear to be binding on you all and may or may not have any persuasive impact. What the Third Circuit has basically said is that, well, after all, the Section 504 regulations require that a free appropriate public education be provided. If you're not providing that under IDEA, then you're not providing it under Section 504. And they kind of just leave it pretty much at that. I've cited the Andrew M. case. There's half a dozen Third Circuit cases that say roughly the same thing. They do allow for the possibility there might be exceptions. The contrary view, the idea that you've got a violation of IDEA, but it's not necessarily a violation of Section 504, has a fair amount of case law support for it as well. I've cited one 10th Circuit case that says that. There's cases out of the 8th Circuit. And interestingly, Mark H., although not the Lemieux case, the Hamamoto case, the second opinion out of the 9th Circuit in the line, seems to say that violation of the IDEA's appropriate education standards does not necessarily mean violation of Section 504's appropriate ed standards, which I guess is maybe just a corollary of what we've already quoted the other Mark H. opinion as saying. The upshot of that, though, I think, is that at least in the 9th Circuit, it would seem that if somebody has merely established an IDEA violation on the appropriate education requirement, you'd have to look very carefully to see whether there actually has been a violation of the language of the Section 504 appropriate education standard before you draw the conclusion that the school system has violated Section 504 or the ADA with regard to provision of appropriate education. Let me just pause for a second on that, because I don't know whether you might want to jump in on any of that topic before we kind of move further.
I don't have any submitted questions.
Nobody's,
but if any of you want to unmute and ask any questions or just kind of have Mark review anything, feel free to unmute yourself and let us know.
Hearing nothing. I guess I'll just move on for a moment. So we talked about this non-compliance, non-compliance. So what exactly is it that is what appropriate education does mean under Section 504 or the ADA? Well, one way of going at that is apart from what we've just talked about would be, so imagine kids who would be covered under Section 504 and the ADA, but who then would not be covered under IDEA. So what could that be? Well, it could be a kid who has a condition other than one of the ones that listed under IDEA. Could be a health impairment that somehow is not covered under the OHI health impairments. It could be a emotional disturbance type condition that isn't severe enough to meet the definitions that are in the regulations that pertain to IDEA, or where the kid does have such a condition but for some reason is found not to need special education, at least as such, in order to learn, which seems to be that sort of other half of the IDEA definition. plainly some kids with some forms of learning disabilities or with some forms of attention deficit problems would probably qualify as being covered, especially under the 2008 definitions of disability under Section 504 in the ADA, but there might still be some doubts about whether they would necessarily all be covered under the IDEA definitional provisions. So if you've got this kid who is what some people would call single covered only under the ADA or Section 504, what obligations would pertain to that kid? And well, that would then mean, I suppose, that Section 104.33 is going to for sure be applicable. What is relevant for that kid is a standard that would be providing an education that's providing the opportunities or providing the services that would in some way be as good as or equivalent to or somehow comparable to those given kids without disabilities. Needless to say, there's not huge amounts of development of that topic. So I actually went back a ways in the outline to try to find what might be of guidance if you do wind up with a case of that type. One kind of obvious way to look is, so what if there's a situation where you have a state that doesn't participate in IDEA? What are the obligations that have been found for those states' kids, because they would then only be covered under 504 or the ADA rather than under IDEA? Well, every state, of course, currently participates in IDEA, but that wasn't always true. New Mexico was a holdout for quite a long period of time. They said, don't give us the federal money under IDEA. We don't want the obligation of providing free appropriate public education to every kid with a disability. The parents of kids with disabilities, needless to say, were not terribly pleased about that. And so they brought this New Mexico Association for Retarded Citizens case against New Mexico, saying that although, or arguing, that although New Mexico hadn't opted into what was then the Education of the Handicapped Act, or what is now IDEA, that the state was still obligated to provide appropriate education to kids with disabilities, again, not under the federal special education law, but under Section 504, which was binding on the state because the state got SCADs, well, not SCADs, it got other education money that would then trigger the obligations under Section 504. The court was a little bit coy about what all was required, but they did say that at the minimum you'd be entitled to such things as accurate diagnosis and identification as having a disability, adequate accommodations and integration into both regular educational services and also things like physical education, vocational counseling, learning and personal guidance programs. You wouldn't be permitted to have what the evidence seemed to indicate, that you'd have great differences in some parts of the state as to what services were provided for kids with disabilities in other parts of the state where they weren't. And that, of course, was the general pattern before IDEA got adopted back in 1975, or its predecessor. You know, some cities in particular had actually quite well developed special education services, but rural areas, generally speaking, had very few services, and places in between often did not as well. And so what the court did require was that educational programs be developed for kids with disabilities, all under the authority of Section 504. Needless to say, New Mexico thought, well, if we're doing that, we may as well take the money, and they did, and so they ultimately opted into what is now IDEA. So we don't have really any further development out of the 10th Circuit as to what the obligations would be. There are a few other cases, though, mostly at the district court level, that do give us a little more guidance. Obviously, there's that language that you find in the Mark H litigation, so that's sort of out there, and says that the regulation basically means what it says. without saying terribly much more. The Lyons against Smith case, which is the one that I've got in the materials and on the PowerPoint, is one that talks about the idea that, well, after all, Section 504 is a non-discrimination statute, so therefore it does make sense for the regulation to say that the needs have to be met as adequately as those of kids without disabilities. But it doesn't really talk much more than that, except to say that that might entail then providing something that you would describe as special education to a kid who qualifies under Section 504 but is not covered under IDEA. So it tells you, yeah, special education may be required, but doesn't really tell you what the content of that is. There's one relatively recent case out of the Middle District of Pennsylvania that I mentioned, that Beam case, which is a dreadful case actually. The student committed suicide actually after a lot of tremendous academic difficulties and problems at school, and the parents bring a damages claim under Section 504 and the ADA, and the guts of the claim seems to be that the kid had a 504 plan, a plan for provision of services under Section 504, but that at least a fair number of the school personnel simply disregarded it or modified it without telling the parents, or otherwise didn't modify it when the kid's needs changed or when warning bells should have gone off. And the court does uphold the claim. It's not clear to me whether anything further happens in the case. I didn't see any further reports, and it may be that the case settled after that. But it does, the court does emphasize this idea that there is an obligation, if not exactly to have a plan, at least if you do have a plan, to follow it and to modify it when the need presents itself. I think maybe by implication it suggests that there has to be some form of a written plan, although Perry Zirkle, who's done a lot of writing on Section 504, actually has a whole article on whether you actually need a Section 504 plan in the sense of a written plan or not, and comes to the conclusion sort of maybe yes, maybe no, after amassing all of the relevant case law on the topic. So it might be a little unclear whether you actually need a written plan, but you do at least have to be responsive, and you have to make sure that services are provided when that's needed to meet the appropriate education standard. What are damages appropriate in a situation like that? You might be thinking, well, maybe again yes, maybe again no. Precisely what the standards are for damages relief is an open question as well. The court there thought that some showing of deliberate indifference is needed, and there's some authority for that proposition, but they also thought that the failure to respond to the kid's rather obvious needs would be adequate evidence of deliberate indifference if that were required for a damages claim. I did also find one relatively recent District of Hawaii case that I thought would be worthwhile pulling up in this connection as well, and that's that Jason E. against Department of Ed State of Hawaii case that's on page 9 of the written materials. This is again a kind of a challenging case, although one that doesn't have as grim an outcome as the previous one. Kid has Down syndrome, 13 years old, performing at a fairly low academic level, maybe at about a first grade level, and does have some fairly serious behavioral problems, although how serious was kind of a matter of dispute. The parent wants the kid to be in a charter program that is partly online and partly not online, a sort of a hybrid program. The school system in Hawaii says, well, look, the charter system, the charter program that you're enrolling the kid is not really appropriate for a kid with these needs. We can serve the kid. Enroll the kid in the local school and we'll set up a whiz-bang program for him. the parent doesn't want that and insists instead on the cyber/classroom hybrid charter system. It goes up to court ultimately on whether the parents are right or the school district is, and the parent is kind of relying on Section 504 and the ADA to keep the kid at the charter program, with not really necessarily a bad sort of theory. I think that his theory, the parent's theory, was that, well, if you're allowing non-disabled kids into charter schools pretty much at parental choice, you've got to do the same thing for disabled kids, and with enough accommodations, this program could work for my kid. The court says a couple of different things. On the one hand, it says, well, look, they've offered appropriate education that would meet a Section 504 standard, or for that matter, probably an IDEA standard, under the regular public schools, but you're not taking it. In fact, you, the parent, have withdrawn your consent to IDEA services, but if you were willing to do that, you'd be offered appropriate ed. So really the case is moot. I pointed out in the outline, I think that that's a kind of dubious holding, because the Supreme Court just last year said, in a completely different context, one involving a consumer class action, that if a defendant offers a plaintiff everything that the plaintiff wants, but the plaintiff still doesn't take it, that might be unwise on the part of the plaintiff, but it doesn't moot the case. Justice Ginsburg sort of puts on her civil procedure teacher hat and says an unaccepted offer is a legal nullity, and so therefore the case is not moot. On the other hand, the court here, I think quite wisely, also found an alternate basis for the holding. What it said in the alternative was that the parent hadn't really given any evidence in support of the accommodations that they felt the kid needed in the charter school. And so the claim that the appropriate education obligation required that all of these additional services, like more one-on-one or more technology or other such things, were needed, just wasn't there. That being the case, the court thought that the parent lost simply on the basis that there wasn't any evidence to support the Section 504 claim. And obviously you can never really tell exactly what's in the record and what's not in the record in a decision of that type. But if the parent is not able to come forward with evidence that would show what would be a reasonable accommodation that would accomplish what the kid's needs, would accomplish meeting the kid's needs, it wouldn't be surprising that the parent would fail. Some of the other things, like accommodations like an aid for field trips or preferential seating, all those things are probably things that would be desirable, but again, the court thought that they were not needed to meet the FAPE obligation under Section 504. Isn't really a whole lot more out there. There are some other cases here and there. I've got a couple of law review articles that I cite at the end of the outline that will have a little more authority here and there, but it's still kind of an undeveloped area, and it would be interesting to see if more cases do come up that are arguing this meeting kids as adequately as the needs of kids without disabilities are met. But at the moment, we're still kind of fumbling a little bit as to just what that would mean in application. So let me move on to maybe the next topic. We can debate a lot about what free appropriate public education requires under Section 504 in the ADA, what it requires under IDEA. The question then is, so if you've got a case that doesn't involve a claim for appropriate ed under Section 504, but rather for something else, or for something else in addition to appropriate ed under Section 504, what about those kinds of claims? And it's interesting, there's actually a little more development with regard to those kinds of claims. than there is with regard to other kinds of claims. And so I'd like to maybe get into some of that material now. So I put in the materials here the basic requirement under 504, and you can see it's actually codified as Section 794 of 29 USC, and it's this basic thing of just non-discrimination, and then a delegation of rulemaking power. And I've listed the basic regulations, not only the one dealing with appropriate ed, but other things like location and identification of kids, academic and non-academic educational settings, evaluation and placement, procedural safeguards, non-academic services, and a few other parts of the regulations. But as I mentioned, although the Section 504 regs give you a fair amount with respect to education, and that's not surprising. They were promulgated by, actually originally, the old Department of Health, Education, and Welfare Department before it got reorganized under President Carter into the Department of Education. There also are quite significant regulations that were promulgated by the Department of Justice under the portion of the ADA that relates to state and local government services, including public education, including preschool through secondary school, which would be what IDEA would then ordinarily cover, education. The regulations, as you could probably guess from the fact that they were promulgated by HEW back in the middle 1970s, under 504 for education haven't been revised since then. That's why they're still using the handicapped, non-handicapped language. On the other hand, the ADA regulations have gone through a few different phases, and most recently were revised in 2010, effective 2011, and were made much, much more elaborate and in some ways much more definite in that last iteration in 2010, 2011. You might wonder if you haven't confronted ADA-related stuff before, why we spend so much effort on the regulations and relatively little, except for the definitional stuff, on the provisions of the ADA dealing with state and local government. And the short answer is that the drafters of the ADA thought that by and large Section 504 had worked fairly well at the state and local government level, and they thought that there'd probably be less resistance at the state and local government level if what they imposed under the ADA provisions looked like the provisions under 504. And remember, with 504, you've just got this one kind of general, vague thing in the statute, and then a lot of rather specific regulations, either from education or from Department of Transportation or any other various federal agencies. In the ADA, what the drafters did was, for the state and local government provisions, just have a general prohibition on discrimination with a little bit of supplementary language, and then say, oh, and by the way, Justice Department, as the lead agency, promulgate regulations to enforce all of this and interpret all of this, and by the way, make them conform to regulations under Section 504. So the general provisions of the state and local government stuff in the ADA, Title II, are really very modest. It's mostly just this delegation of authority and the delegation to make it look like 504. But that being said, the drafters of the ADA regs did go ahead and cover stuff in a somewhat more modern and, with regard to some things, rather more specific way, certainly than were found in the education regs under 504. And so we really have to look at both the ADA regs and the 504 regs in trying to figure out what's binding on entities like public education. And so what I've got listed in the outline on page 10, kind of not exactly parallel to, but at least next to the regulations on 504, are the ones that ADA has for general prohibition on discrimination in the statute, enforcement in the statute, delegation of power to make regulations, and then with regard to the regulations, general prohibitions, retaliation. Interestingly, there's kind of a harassment provision that goes beyond retaliation. Service animals, mobility devices, accessibility, and then finally communications. And those were all things that were revised in 2010, effective 2011. To say a word or two about some of those, so non-exclusion and non-segregation, there's been a little bit of case law development on that. And interestingly, some of it does come from the Ninth Circuit, although the case that I found that looked to be the most recent and the most interesting of the bunch is Chatham, which was actually a non-precedential decision, although Lovell v. Chandler, which it relies on pretty heavily, is precedential, although doesn't involve education. The Chatham case is a case where a kid was kept out of school because he had a genetic condition that indicated markers for cystic fibrosis, but didn't actually have the condition, didn't actually have cystic fibrosis. The school district apparently went into some sort of a panic and kept the kid out of school. The kid's parents get an injunction from state court in California to get the kid back into school and then sue for damages and prospective relief as well under the ADA in Section 504. And the Ninth Circuit reverses a dismissal of that claim, so allows that claim to go forward, saying that, yeah, you know, you can't exclude a kid, and we think what's more, that when you're looking for a damages relief, as they seem to be in this situation, that you don't necessarily have to show animosity towards a kid with a disability as long as you excluded the kid on the basis of disability. And that's really enough, or in this instance, a perceived disability. And so they said that that form of facial discrimination is something that would qualify as intentional discrimination and in turn could support a damages claim. The basic idea being, though, that exclusion in and of itself would seem to be something that is prohibited under the ADA and under Section 504. Doesn't mean you can't provide separate services. You know, if that's the way in which you can best meet the needs of the kid, obviously that would be the case. Or if there were actual danger, but that has to be evaluated on a quite specific basis with regard to the kid, rather than just being done on the basis of a diagnosis itself or some sort of a general rule that doesn't provide for individualization. I also listed, there's a Seventh Circuit case that has gotten a lot of notice where I am, not surprisingly, being in Chicago, but where a kid wasn't exactly excluded, but it was I guess some people would say a sort of high-functioning kid with autism, for whatever that means. But the idea that the kid had autism, but with a lot of work, could pretty much hold his own in school. But his allegation was that the teachers were reluctant to actually give him the accommodations that the school district had provided for in his plan, and generally were trying to keep him out of the more advanced classes rather than create the accommodations needed for him to succeed in those classes. And the Seventh Circuit, interestingly, said, yeah, that is a form of exclusion, and they too reversed a dismissal in that situation, saying that, yeah, that claim could go forward, and the district could be liable for exclusion based on that sort of pushing out, or pushing out by virtue of failing to provide required accommodations theory. That now is in the lower courts, and I don't know what will happen with it. It could be that whatever the parents put in the complaint will not be able to be sustained, or it could be that what they put in the complaint will be able to be sustained. It'll be interesting to see what ultimately happens, or whether the case, as I kind of suspect it might, winds up ultimately settling. So that's really, I don't have terribly much more to add on exclusion or segregation. There are a few older cases dealing with kids with HIV from back in the early 1980s, but I think that most school districts are savvy enough, by and large, to avoid making determinations of based on safety that aren't well supported or well thought out. I would hope at least that that's the case. What have we got in the area of reasonable modifications? So this is actually a slightly different idea from the appropriate education idea, although obviously there's an overlap. You know, the employment provisions, for example, in the ADA have always been thought to include the idea of reasonable accommodation, and that's spelled out in the statutes, spelled out in the regulations as well. You would think that, yeah, something like that would probably be equally applicable in other areas like state and local government services, and quite specifically in education. A lot of the cases that have been decided under reasonable modifications ideas are ones that have been decided not by the courts, but rather by the U.S. Department of Education's Office for Civil Rights, which hears complaints, does investigations, and then usually works out an agreement with the school district or other federal entity, a federal grantee entity that's covered by Section 504, and appropriate action then is taken to remedy and provide the required reasonable accommodations. Interestingly, that can be true for segregation and for exclusion as well, but there's a lot that goes on with regard to reasonable modifications. I thought I would throw in at least one of those cases, and that Duneland from Indiana School Corp case is exactly one of those. Kid has cancer. The chemotherapy, not surprisingly, causes all of his hair to fall out. His 504 plan requires the school district to allow him to wear a cap so that he doesn't have to show his baldness if he doesn't want to. But needless to say, the school district has a policy against allowing kids to wear baseball caps. And he has all sorts of trouble actually getting the school system to comply with that part of the 504 plan that he's got. And ultimately, he files a complaint with the Office for Civil Rights, which marches in and says, no, you can't do that. You've got to actually promulgate the 504 plan to all the personnel who might come in contact with the kid. And ultimately, the way they resolved it was by allowing kids without disabilities to wear baseball caps. So it winds up kind of universalizing the remedy in a way. Are there other cases that maybe are a little different? Yeah, there are a bunch of them. Some of them, interestingly, go one direction, some of them go the other. There are things like transportation modifications. That's that KK case. There's a interesting case called Indiana Area School District that's actually out of Pennsylvania against HH. There the court said that the kid was entitled to reasonable modification of what would otherwise be generally applicable discipline procedures. So kind of modification of things that might otherwise get the kid tossed out of school or suspended, being qualified as something that would be under the reasonable modification duty. The AG case, which we'll talk about as well, which calls for additional modifications, is another one on that line. So we've got really a decent smattering of cases calling for various kinds of modifications under the reasonable modifications obligation. There are other cases, though, that kind of go in the other direction. So the kind of interesting one, this Pollock case, where the kid comes home with bruises. The mom then says, well, as a reasonable accommodation, I think the kid who's nonverbal, and I believe has autism, autism and a language disorder, should be permitted to wear a real-time recording device so I can see whether he's being manhandled or being abused or whatever is the explanation for coming home with bruises. I think the court actually had some trouble trying to figure out whether that could be a reasonable accommodation or not. Ultimately holds that it's not, because it could cause a disruption, could cause difficulties, and didn't think that the showing was quite strong enough to require it. But the parent also, perhaps quite wisely, brought a First Amendment claim saying that I have a right to record what's going on, kind of comparable to arguments that have been made in police brutality situations where people have gotten access to recordings or protested against being told by police to shut off that cell phone or that sort of thing. And the court then applying the First Amendment case law, which is the Tinker and other cases that deal with the ability to exercise free speech, said that you might have a viable claim there, and allows the court, or allows the case to proceed to court under a First Amendment theory. And what's going to happen on that, I have no clue. There's actually been an appeal filed, which I have a sneaking suspicion is going to get dismissed because, after all, half of the case still hasn't been litigated. But we'll see what ultimately happens with it. There is another case that I think is of some interest, that RK case. Folks may know under IDEA, by and large, claims made by kids to stay at their neighborhood school when they need services that the school district, for economic reasons, would rather concentrate at a school that's farther away. Most of those claims have failed. There's a case called White against Ascension Parish from the Fifth Circuit. There are a large number of other cases that say basically that that's okay as long as the school district provides ample opportunities for integration of the kid. The kid doesn't have an entitlement to be at the neighborhood school. You can, interestingly, I think, make an argument under Section 504, kind of apart from the IDEA claim, however, that, well, yeah, maybe you can do that under IDEA, but if you've got a reasonable accommodation obligation under 504, as well as an obligation to treat kids equally under 504, maybe there is an entitlement to the neighborhood school and to services to enable the kid to stay at the neighborhood school under 504, whereas that claim would fail under IDEA. And that's what the RK parent tries to argue. The kid has diabetes. The school district wants to put him at a school that has a full-time nurse. He wants to stay at the neighborhood school and wants the nursing to come to him, basically. And the court says, no, that's not encompassed within what we think is reasonable accommodation. The accommodations that they're offering, namely to send you to another school that has equally good services otherwise, is all that's required. And so that's the RK case. There are other cases on reasonable modifications, but not, again, terribly many. And these, I think, give you a sense of what courts have done in the areas. In some instances, they've made significant modifications or allowed significant modifications. Others, they've said, nah, that's not what we think the statute actually requires. Are there still other things? Well, of course there are, needless to say. Child find has been a big issue under IDEA. A lot of parents have made claims, look, you, the school district, should have realized my kid had a disability. You should have alerted me. You should have alerted yourselves, and you should have provided services long ago. To some degree, sometimes those cases look to be ones that are trying to get out from under what would otherwise be statutes of limitations. What they're saying is that I had no reason to know the kid had a disability, so therefore I didn't bring a claim that now I'm bringing for compensatory ed or for back tuition because you, the school district, failed to do your job of identifying the kid and alerting me of the fact that the kid had special needs. The regulations under Section 504 have kind of comparable language that also requires identification and location of kids with disabilities under Section 504. And you do see some authorities, although not terribly many, once again saying that it's a violation of the 504 regs to fail to provide this identification and determination of whether the child has needs. And especially given the fact that there's at least a possibility of a damages remedy here, it's again perhaps not surprising that parents might sue for the failure to identify a kid under Section 504, either ignoring IDEA or in addition to an IDEA claim. And so I'm kind of providing another relevant case here. This is another one of these rather dreadful cases of a kid who has various mental health issues and ultimately commits suicide. What the parent contends was that there was severe peer harassment, and that's what pushed the kid ultimately into a mental health crisis and into the suicidal behavior. The parent said, you, the school district, should have realized that she had special needs and that accommodations were required. By the way, some of those accommodations being ones like protection from harassment and other things to prevent the harassment from occurring. The court ultimately sides with the parent, at least to the extent of denying a motion to dismiss. The parent actually brought the claim under Title IX as well, saying that some of the harassment was sex-based. The claim under this identification idea was there were enough warning signs the school district should have known something and should have acted on it. Probably those are ones that might have said, yeah, maybe the parent should have been acting as well, but nevertheless the court does uphold the claim. Facts included a drastic weight loss in the kid, tanking of the kid's grades at school, and some signs of self-harming. And so the court does uphold the damages claim brought by the parents on behalf of the kid's estate. That's also quite recent, so I don't know what ultimately will happen with the case. One thing that I've always thought was interesting, but that is pretty much undeveloped in the case law until real recently, is the 504 as well as the ADA regulations call for prohibitions on practices that have disparate impacts on people with disabilities unless the defendant basically is able to meet a educational necessity or business necessity kind of a defense of those practices. And that can include testing, it can include any number of other sorts of things as long as there's a disparate impact on the people with disabilities. There's a Supreme Court case called Alexander against Choate from the 1980s under Section 504 that says, well, under 504 it's quite clear Congress didn't mean to cover every governmental decision with a disparate impact, but it probably did mean to cover a lot of things with a disparate impact. And one of the things that the Supreme Court mentions is education, an area in which a disparate impact might be something that Congress thought was actionable under Section 504. Since that time, as I said, there hasn't been all that much development, however, but the WH against Tennessee Department of Ed case is one where the really a proposed class of parents are arguing that a bunch of practices, including the use of some software, funding allocation decisions, other things, had a disparate impact of shunting kids with disabilities into unnecessarily non-integrated or unnecessarily disabilities-only type placements. And the school district comes back and says, these are just our practices. We do make individualized decisions for kids. Maybe in if there were something that didn't have any individualized characteristic to it, you could say there's a disparate impact. But this isn't what's covered under the law. The the court actually disagreed and denied the Tennessee Department of Ed's motion to dismiss and the county school system's motion to dismiss, and said that if you did adopt practices that did have this impact, then that could support the violation. It also kind of cautioned that, look, the evidence here is not in. It's not obvious that there is a disparate impact from these practices, or if so, that whatever disparate impact isn't justified. Well, we're going to hear a lot more once we have discovery and get to summary judgment, but at least it said that a claim of that type could be sustained. Whether that would actually have an impact on you all as hearing officers, I'm not quite so sure. I could imagine, I guess, a parent bringing an individual disparate impact type case, but you know, in most areas, disparate impact claims have been brought either by classes or by groups, and so it's a little unlikely, I think, that that would wind up before an individual hearing officer. But if you do, the WH case would probably be a place to look. Let me mention a little bit about harassment and abuse and inappropriate restraint and seclusion and all that sort of thing. Here I was able to locate some Hawaii authority, and so I thought that it might be of particular interest and might be of guidance if you're looking for cases that might be relevant here. So the one case is the Kimes against Matayoshi case from actually just this last October. Kids got autism spectrum disorders, got epilepsy, variety of behavioral problems, has a fairly elaborate behavioral plan. The behavioral plan, I guess in keeping with the fact the kid does have autism, basically forbids restraining the kid and says use other ways of dealing with the behavior. And in fact, it did appear that that there were other ways of dealing with the behavior for this particular kid. That if the kid were ignored, essentially that most of the disruptive behavior would sort of peter itself out. In any case, the kid does ultimately bolt from the classroom and is grabbed and restrained even after the kid has stopped moving and is lying down in what the kid had been taught to be was a quote, safe position. And they grab him and drag him back to the classroom, and the parents sue for what they claim would be a damages for physical and emotional harm that the kid sustained. And the court in that instance, interestingly, denied not just a motion for dismissal, actually denied a motion for summary judgment based on the evidence and said that claim should go to trial. I think what was key to the court's reasoning was the idea that the school district itself had made a decision that restraint was not a good thing for the kid. Had that not been the case, maybe the court wouldn't have felt the same way, but it used a lot of language of reasonable accommodation, and it seemed that they thought that the accommodation of not restraining was reasonable because, after all, the school district seemed to have endorsed it for this particular kid. So that might be of relevance. There's another case where a kid was confined in a, or basically restrained in a posture chair, and it was the parents' contention that the kid didn't need that and basically was being restrained in the chair because it was a way of just babysitting the kid and ignoring what would otherwise be the kid's needs. The court there denied a motion for summary judgment as well, once again saying that, yeah, this is something that really has to go to trial as to whether they actually needed to impose that kind of restraint of movement on the kid or not. There are a few other cases that are out of district that may also be of some interest here. So one of them, this IL against Knox County Board of Education case out of Tennessee. The kid here isn't confined in a chair, but is confined in a 4-foot by 4-foot alcove of the school that's fenced off with gym mats to keep the kid from getting out. It also, at least arguably appears that the kid is simply being babysat there rather than being able to get any educational benefit of being there. But it's worthy to note that unlike the kid in Rick's, the kid here was not, although it seemed that he fairly frequently was restrained. He was restrained, I think, something like 21 times. It wasn't for all that long. There was a grand total of 4 hours of restraint during that time period. But the court did uphold a claim there against a motion to dismiss. Also upholds a claim under the state law pertaining to isolation and restraint of kids. The court is, should I say, somewhat cautious about what kind of remedy would be appropriate and whether a damages remedy could be provided. It denies the motion to dismiss, but doesn't really play its hand much or give away its hand very much about what all is going to be required to make a damages kind of a showing. I also should say they quote something I wrote, so of course I think it's the best case ever decided. The Bowe against Eau Claire case is one out of Western District of Wisconsin. This is also one where the parent's claim survives a motion to dismiss, but it's a pure harassment case. There are a few others that do something similar to that, including a litigation out of Minnesota that upheld a damages claim and ultimately affirmed a judgment for damages against a school district, with the gist of it being that the peers are engaged in harassment, the school district knows about it, could do something about it, and doesn't do anything about it. In cases where the school district knows about it and does something about it, even if the something doesn't look all that adequate, the school district seems very often to win. I thought I would throw in a relatively recent case where the school district does not prevail, but you should probably be aware of a general pattern of cases that if the school district has made adequate responses, like by disciplining the kids who have been engaged in the peer harassment or otherwise dealt with the peer harassment in a sensible way, the parent's claim tends to fail. And I do list a number of cases in which the parent's claim has failed. So the Doe against Columbia Brazoria case out of the Fifth Circuit is one of those that actually involved an assault that arguably was sex related and so could be covered under Title IX, as well as disability related and therefore covered under 504, but where the parents didn't properly allege that the school district had actual knowledge of the risk. The Gold case out of the Sixth Circuit, which I was a little surprised at actually. Kid has what I guess would have been called in the old days water on the brain, or the hydrocephalus condition. There's a highly abusive teacher who obviously shouldn't be in the classroom and ultimately winds up getting thrown out of the classroom, who treats both this kid and other kids quite improperly, and at one point snaps the kid's head back, according to the parent, causing quite significant harms to the kid. And the court says, no, that isn't a valid Section 504 claim, among other things saying that you didn't show a denial of educational benefit, and also that, well, there wasn't any comparable situation of where a kid without a disability was treated better. For the denial of educational benefit, that seems a little extreme to me. I mean, for the one thing, cases like Barnes v. Gorman, which is the only case that's gotten up to the Supreme Court on a damages claim under the ADA against a public entity. There was a person in a wheelchair who was injured because the paddy wagon wasn't accessible. The court didn't do anything to overturn the compensatory damages award. It did overturn the punitive damages award, but that would seem to be not related to anything except for the injury, and that was what was compensated. For the idea of not requiring or requiring a sort of comparison who was treated better, you know, cases like the same-sex sex harassment case, the Oncology case in the U.S. Supreme Court, as well as the cases under Title IX dealing with sex harassment, would seem to dictate that you don't need a comparison case in an instance of harassing behavior or improper physical or mental behavior. So I would at least be somewhat skeptical of that result. Nevertheless, it is what the Sixth Circuit came up with, and cert was denied. So it's certainly a claim that may be entitled to persuasive authority if you agree with the reasoning in it. Let me pause again for a moment here, just in case there has been other stuff that you've been thinking about, but because I've been talking on without a break, you haven't had a chance to jump in with.
I don't have any written submissions, Mark, at this point, but
No?
if anyone has a question, unmute yourselves and ask your question directly of Mark, or if you have a comment, feel free to weigh in. Okay.
All right. Well, then I'll just plow ahead. But again, feel free, because after all, it's not a huge session, and you know, whatever we can do that might be responsive to any of your concerns, we'd like to do it. What I'd like to turn to next, if there aren't any thoughts from you folks, is to talk a little bit about discipline protections. And here I've really got a series of cases, and I don't really want to belabor the point, but there's a fair amount of authority here that you might want to be aware of and might want to turn to if you've got a Section 504 claim in front of you that deals with the kid being suspended or being expelled or otherwise being subject to school discipline. And as I say, the grandparent case here is this one from 1981 from the Fifth Circuit, S1 v. Turlington. Interestingly, it involved claims, some of which were from the period before IDEA became effective, or it was then the Education for the Handicapped Act became effective. So it essentially said procedural protections and protections against discipline for conduct related to the kid's disability were required under what is now IDEA for the time period after IDEA was effective in October of 1977, but was also required before that period of time under Section 504. And basically it was exactly that, so that a kid couldn't be expelled without procedural protections, a right to a hearing, and that the kid couldn't be expelled for behavior that was a manifestation of the kid's disability. And it really is, as far as I know, the first instance where the courts sort of developed this idea of behavior that results from the disability as something on which the kid can't be excluded. That had been actually part of the reasoning in the cases that led to the adoption of IDEA, most notably the Mills case in the District of Columbia, decided under an equal protection and due process theory. But it was interesting to see it surface under a Section 504 theory in 1981. And those of us who were working in the field in that era, which includes me, were rather surprised that the court came up with it. But of course, it then gets embodied ultimately in the written text of IDEA, as well as being a valid precedent for interpretation of Section 504. I've thrown in a few other cases that aren't really terribly much different, but apply the same reasoning in a more recent context. So the 2011 case, NT against Baltimore City, require a manifestation determination. Yeah, they did actually do a manifestation determination, but apparently they didn't bother to tell the parent, which was a bit of an objection on their part. The Doe case, on the other hand, against Osseo, that one they did hold a manifestation hearing, and the court says it's okay under Section 504. there are other cases. The AG case I thought I would throw in here just to sort of emphasize it a little bit. It's essentially another case dealing with the idea of what kind of behavioral services have to be provided, what kind of accommodations need to be met before the kid can be either suspended from school or subject to restraint or subject to discipline of one sort or another. It's important, I think, in part because it's a Ninth Circuit case, so it does directly bind the relevant courts and hearing officers, but also it suggests that if you are wrongfully applying restraint as a disciplinary measure, that is a Section 504 valid kind of a claim that arises. Also has the interesting point that even though the parent agreed in writing to the placement, that doesn't waive the Section 504 objection if the parent makes it later. Again, you may not be all that persuaded by that. I'm not sure every court would be, but at least as I read the AG case, that's essentially what it seems to be saying based on the facts of the case. And they say that the allegations that there should have been a functional behavior analysis and a behavior intervention plan could provide a Section 504 and ADA claim. But I thought I would necessarily then throw in a case that maybe goes in the other direction a bit. So the JV case does actually say that there's no valid Section 504 or ADA claim on behalf of a second grader who winds up getting handcuffed because of misbehavior, saying that they couldn't chalk that up to the kid's disability, and that, again, there was no obvious denial of educational benefits in the case. I thought I would throw in as well, there's an interesting Dear Colleague letter that came out of the Office for Civil Rights that basically says if you're using restraint or seclusion a lot, it probably means the kid has a disability and ought to be identified, and that probably the kid's placement or other services then need to be adjusted. I think that might be of some persuasive value and therefore might be of quite a great deal of importance in a case, particularly one dealing with a kid whose parents say that the kid should have previously been identified as having a disability or should have gotten services under Section 504 of the ADA. I also wanted to mention, although I didn't put it in the PowerPoint, I figured that you might have more familiarity with this than I would. But you know, the Hawaii administrative procedures under Section 504 do have a whole section on discipline of kids who are qualified under Section 504 in sections 8-61-13 and the sections that follow that. What it does pretty much is adopt what's in Section 1415K, the disciplinary provision stuff of IDEA. There are a few differences, but it's generally rather similar. There doesn't seem to be the language with regard to bodily injury or with regard to weapons and the ability to exclude a kid even without a manifestation determination based on that, or at least to move the kid to an interim placement based on that. But it does allow for that for drug-involved cases. It does generally provide for review of manifestation, and so otherwise tends to look a lot like what's under IDEA. Finally, let me just mention three other extra categories that have had some development and maybe will get more development. KM in the area of communications is, to my mind, one of the biggest developments that's happened in special ed law, at least short of what the Supreme Court did this year, really in quite a long period of time. What the case, actually it's a couple of cases, but what it involves is kids who are high performers in school, but who also are deaf. What they contend is what they really want in their classes is CART, which is kind of spontaneous written translation of what's said in class on a screen, either in a big screen in front of the classroom or on a laptop. That at one time was incredibly expensive. Now is much, much less expensive because it can be done over the internet and is probably not that big a deal. But it was denied either in whole or in part for these kids. The kids then ultimately graduate from high school. They do real well academically. They bring claims under IDEA and under 504 and the ADA, principally relying on the ADA. Their IDEA claims, not surprisingly, fail because they're succeeding well in mainstream classes, and Rowley, would dictate they don't get anything more than whatever they've got. But the Ninth Circuit sustains damages claims under the ADA because the communications regulations under the ADA say you've got to provide equally effective communication for people being served by public entities who have disabilities as you provide for people who don't have disabilities. And CART seems to be the way in which you could have equally effective communication, not just sort of adequate or bottom line communication. And part of the argument and the claim for damages here really was that the kids were going home with headaches every day because they were high achievers and they wanted to concentrate so hard on their lip reading or on their ability to use residual hearing or hearing aids that it was driving them nuts, and that they really did suffer the equivalent of physical injury. And so the CAM case upholds that kind of a claim against dismissal. And now there appears to be a case that's more or less on the track to trial. I don't know whether it might have ultimately settled by now, but the Poway Unified case that you see listed there is one that is a damages claim where the court says it's got to go to trial because it looks like a plain old damages claim, where the kid has graduated and now wants relief for the headaches and everything else. I thought I would also just throw in, there's been a bunch of cases out of the Office for Civil Rights requiring accommodations for websites to make them accessible to people with visual impairments. Service animals, there's stuff on those as well. Service animals are covered quite elaborately under the ADA regs that were promulgated in 2010. The Fry case that came out of the Supreme Court is one that seemed to develop whether exhaustion is required in a case for having a service animal at school. And the court, although it doesn't say that exhaustion is not required, does say that in general only free appropriate public ed claims are ones that need to be exhausted. And if you could bring the same claim for a non-educational setting, like your dog was excluded from a public library, or if an adult with a service dog could bring a similar claim, it's a claim that doesn't require exhaustion. That, again, probably is not all that significant for you all on its face, because if you've got the case, that means somebody is doing administrative exhaustion. But I think what's significant about it is that it probably will raise the visibility of Section 504 claims. And so for that reason, maybe we'll just mean more business coming your way on the 504 front. I did throw in a couple of cases that actually do deal directly with claims for service dogs and whether they're required or not. U.S. against Gates Chili, which requires accommodations to have the kid in, at least subject possibly to some objections, and the Albaniga case, which goes roughly the same way. There is actually a case that's in the outline under direct threat where the dog bites, and so in that case the court does not allow relief under the ADA, but otherwise that's been done. Stanek is a retaliation case, or it also has retaliation claims to it. There are a lot of retaliation cases under 504 and the ADA, and they're decided just like the retaliation cases under employment. So I didn't really put in terribly much more here. Stanek does have a bunch of citations to other retaliation cases if you're interested in digging that up and have such a claim in front of you. So that's then that whole wad of stuff dealing with things other than the free appropriate public education obligation, but also obligations that are imposed under 504 and the ADA. And so I'd probably be inclined for a moment then to shift gears and to get into what are really the final parts of the outline, which are, on the one hand, hearing officers, remedies, procedures, and all stuff like that. And then on the other hand, defenses to the various claims under Section 504 and the ADA. And I do begin with a kind of a tiny bit of an apology that there hasn't been much development that I've been able to find on procedures and remedies. I did try to put as much as was out there as of about 2010 in the law review article that's cited at the end of the outline. But again, it's less than might be expected. Hawaii's administrative regs do actually include some stuff on how to conduct the hearing, and more specifically, kick you back into Section 91.9 of the Hawaii Revised Statutes, which say generally what an administrative hearing has to do. So I think if you're looking for guidance, it probably would be under the Hawaii Administrative Regs and under 91.9. And as I said, that does include things like notice, rights to cross-examination. Interestingly, it doesn't require a recording unless one of the parties asks for it, but does require that a record be kept that would include whatever testimony has been recorded, would include documents, would include motions, written stuff, everything else, and that there would be a requirement for a written decision. 91.9 contemplates the idea that in general, administrative agencies are going to have hearing examiners or officers who make kind of a recommendation to the head of the agency that then would be finalized by the head of the agency. As I read the Hawaii administrative regs dealing with 504, that's not the case. Instead, the hearing officer decision itself is final, and that, if anything, would be subject to review in the courts. And the regs do provide for review for it in the courts, although, oddly enough, there have been a few cases that have said there really isn't review under Section 504 in the federal courts for an administrative decision that goes against the school district, because the school district can't claim violation of Section 504. Now, whether there might be a state law cause of action, under the General Administrative Review Act, or under what in the Midwest here would be a common law writ of certiorari, the courts never say. But it is interesting that there might not be federal jurisdiction for a claim in which the parents prevail if the school district wants to take that up on appeal. Some other things that have been developed. Oh, yeah, please.
Can I ask a question? Would compliance with the procedures in IDEA, although the Hawaii administrative rules don't say this explicitly, but if you comply with the IDEA administrative procedures or the hearing procedures, would that satisfy most, if not all, of 99.9?
I think that's right. I think it would. There's some stuff like the pretrial or pre-hearing disclosure stuff doesn't seem to me, at least, to be spelled out at all in the 504 or the Hawaii administrative regs. But, the idea that you'd be adopting that just as a matter of good practice seems to me to be quite plausible. And otherwise, it does look a lot like the IDEA procedures.
Okay.
So I think that point's well taken.
Thank you.
A couple of other things. I threw in the Lyons against Smith case, which simply says that the hearing officer in a 504 case can give prospective relief. Nina, which says that compensatory education can be awarded, and that actually might be a more appropriate remedy than compensatory damages in a given case, is also one that might be of interest here. Lynn Beekman, who we work with at Special Ed Solutions, found a case in which a hearing officer in Massachusetts, I should say, in Massachusetts ruled that damages were not permissible relief that a hearing officer could give. Although the hearing officer there relied quite strongly on Massachusetts regulations, so I'm not sure how broadly applicable that is. But of course, you can imagine a hearing officer saying, you know, look, I don't have the ability to give damages relief. If you want that, you're going to have to take the case up to the courts. And it could be that, that would be right. It could be not. I guess it would really just depend on what the authority is under your state law. And my guess is that there isn't a whole lot of authority under the state law, and so you'd have to figure it out based as best you could. For what it's worth, that Massachusetts case is called Natick Public Schools, N-A-T-I-C-K, Natick. And I really do have a strong Midwestern accent. I guess I have to apologize for that. At 108 LRP 10435, and it's from back in 2000. Otherwise, you know, the case that doesn't uphold, the case that does not have an appeal of a compensatory damages award, but knocks out a punitive damages award as not being something intended under the ADA Title II, is Barnes v. Gorman, decided by the Supreme Court in 2002. I put in the, let's see, we're on to the next, no we're not. Oh, you know what I wanted to do, let's see if we've got it here. Bear with me just a second, I'm trying to keep my, my stuff straight. I did want to mention with regard to remedies, you know, not just the idea of damages, but also a word about attorney's fees and expert witness fees. And I didn't put this in the written material, so let me maybe just give you the relevant citations if I can. There are fees provisions in the ADA at section 12205, and under 504 at 794A, parenthesis B, close parenthesis. Now those seem to be attorney's fees in court, so you might wonder whether there are fees available for administrative proceedings. You might not care, because after all, you wouldn't be getting that claim anyway. But the general rule traditionally has been that if you have to exhaust administrative procedures, you can then go to a court and get the fees, if you could ultimately get the fees if you were in court, which is kind of the way that IDEA does it. But again, that might wind up ultimately getting spelled out. That MW case that's mentioned in the PowerPoint but is not in the outline is a 2016 Westlaw 3959073. And it says, you know, unlike IDEA, there's expert witness fees under the 504 fees provision, so you could get that at least out of a court, and that would be a remedy. We're kind of running low on time, so maybe just let me mention a word or two about relevant defenses. So exhaustion is kind of the big one, but again, probably not all that important from your perspective, because if they're bypassing exhaustion, you're not getting the case. But that's what that Fry case has to do with, and it interprets 1415L. For limitations, it doesn't seem that there's a whole lot of guidance as to what the appropriate limitations provision is. AC, which I did not put in the outline but did put on the PowerPoint, is at 191 F sub 3rd 375, and I can actually email you all of these kind of extra sites. And that seems to apply an IDEA statute of limitations. By and large, courts have said that 504 and ADA validly abrogate state education departments' 11th Amendment immunity. So 11th Amendment immunity does not work as a valid defense. There are a couple of cases, like the one involving the dog bite, or the biting dog, that are in the outline, the AP case. And there's that Chatham case about the kid with the markers for cystic fibrosis that deal with the direct threat defense. So that would give you a little bit of guidance on that. Finally, I thought that I would mention the letter to Zirkle. So that's the one that's referenced at the very end of the outline. You would think that if reasonable accommodation is required, and reasonable accommodation up to a limit of fundamental alteration is what in general the ADA requires, and with slight changes the 504 regulations require as well, that a school district might be able to argue that what the parents are arguing for goes past what fundamental alteration provides as a stopping point for reasonable accommodation. But the US DOE has said the opposite, actually. In this letter to Zirkle, and it's been repeated in a couple of other letters, it said that at least cost limits do not provide a fundamental alteration defense to a school district in a Section 504 claim. And I think that's noteworthy. Now, you may know this. The U.S. Department of Ed has been revising almost all of its letters under 504. As far as I can tell, the ones that they've gotten rid of have just been the ones that actually are duplicative, rather than they've been deciding to create major policy change by getting rid of letters. But they did actually modify the procedures for taking OCR complaints that made it less of a routine to accept systemic reviews. So what the DOE might do with regard to some of these interpretations in the future, I'm not absolutely sure. But at any rate, that's the business about defenses, and it sort of runs through the litany from limitations through immunity to direct threat to fundamental alteration. So that basically is what I had to cover. Deostati, is it permissible to take another minute or two if people have questions?
Sure. Many questions from, I know it must be completely overwhelming. You just learned a whole area of law and IDEA just a few months ago, and here we are with 504. So I'm sure it's a lot to absorb.
Yeah, I've been here listening. I just don't have questions at this point, but I've listened all the way through, and thank you.
Oh, no, great. Thanks a lot. You know, if you do have further questions, I'm really easily available by email. And what I'll do is I'll send out these extra sites to Deostati so he can distribute them to you, and he'll distribute my email address as well.
Okay, great.
Yeah, I think other questions once we have a 504 claim in front of us, and we haven't had a specific one yet. So that'll make it a lot more real, but this is very helpful.
Oh,
and you may very well not get a 504. You know, Taryn's not on the line to let me know what was the last 504 claim, but I don't believe there's been any 504 claims in the last few years. At least I don't remember seeing any when I was reviewing the decisions for the last few years.
Yeah. I mean, what a number of folks have said was just the very existence of that Fry case is going to, you know, turn on a light bulb in at least some lawyers that there might be a 504 claim out there. And Lynn Beekman made the interesting point that if the Office for Civil Rights is going to be less hospitable to receiving complaints under the proposed new procedures that they say they're going to be adopting, then that too might be a reason that people would be demanding more hearing officer hearings. But that's speculative too.
Sure.
Well, great. If there's no further questions now, thank you very much for all of your attention. I appreciate it, and I'll send that little bit of additional material to Deostati.
Thank you, Mark. If you guys can just hold on for a few minutes, Mark, if you need to log off, that's fine. I did want to mention to you, I will be seeing you next week. There's a lot that we're going to cover, and the materials are being copied as we speak. I will be sending you an email with one of the documents, and I will explain this in the email. And what I'm going to ask you to do is, if time permits, to review that document ahead of time, because it's going to be a decision writing exercise, and if we can, obviously our time is limited, if we can get ahead by you being familiar with the document as well as some of the facts that are in the case scenario, it would be helpful, and we'll move the conversation along to the actual exercise. Again, if time permitted, otherwise I certainly will review what's in the document when the time comes. But my hope is that we can review, as we've been discussing for the last few months and weeks, issue specification, fact-finding, conclusions of law, and the order, those 4 components of a decision. So I will get that document to you ahead of Monday, maybe later today or early tomorrow, so that if you have some extra time to review it, that would be helpful.
Okay, great. Well, I have hearings, so I may be in and out of that training, but I will be looking at it.
Excellent.
And prepare that.
Yeah, and as anything else, even if you're not at the training, the outlines are self-explanatory. So it's a resource so that when we write them with an eye, that you will come back to it if you ever have an issue. If you miss some of the training, you should be able to go back to the outline and get at least a start to your research.
Right, right.
I have a question about the 504 claims. Who else, like, we don't have exclusive jurisdiction. Where are these claims going to if they're not coming to us?
I would think, and Mark, correct me if I'm wrong, but unless they're filing directly in court, it would be the courts. It would not. It would be you're the only ones who hear 504 claims in Hawaii, as I understand it, at the administrative level on educational issues.
You know, that would be my conclusion as well. Since you've got a unitary school system there, you could have the situation in another state that has different school districts, where the different school district would appoint their own hearing officers and the state might not have control of it. But I think the state is right that it would only be going to you folks unless it's being bypassed and filed directly in court.
We have the attorney that, I guess the attorney that's kind of does the most volume seems to have been just writing, including in 504 every time he does his complaint. Is that right, Denise? He just puts it in there, but we don't know why most of the time?
Yeah, he uses it as sort of a catch-all, and he will readily admit that on the record. So I don't think there's really a 504 claim in any of his cases.
And that's a practice that I've seen elsewhere in other states. It's a let me cover the bases, and again, as we've discussed, if there's a real issue, then you have jurisdiction and you lay out the issue and you decide it ultimately. But if it's not a real issue and it's just kind of thrown in there because it's part of a template, then you want to get that up front, that there's no real claim here, and you want to eliminate that from the issues to be decided in the case early on, and make sure that's made part of the record, so that on appeal there's no question that you provided the parent with an opportunity to present to you any 504 claims, and those were either waived or indicated that they're not moving forward with those 504 claims.
Yeah, I think that's a good point. Any clarification of the record is always really helpful.
Anything else? Well, I certainly look forward to seeing you guys next week, although I'm not looking forward to my flight since it's but I am certainly looking forward to it, and I'm looking forward, since it's starting to get colder here, I'm looking forward to some warm weather, some consistent warm weather. With that, folks, I thank you for your time. I hope this was helpful, and I will see you next week.
Great. Yeah, thank you all.
Bye now.
Thank you.
Bye-bye.
Bye.
Thank you.